Hello and welcome to a new episode of Legal Wrangle on corporate laws. Today, we are going to highlight two important decisions given by the High Court of Bombay on generic disparagement and the High Court of Gujarat on the extent of the power of RBI to issue directions to the bank to see that there is proper recovery of public money. Let's begin with the much talked about case of Hindustan Unilever Ltd decided by the Bombay High Court, where the issue was whether disparagement is possible even when there is no direct reference to a particular product in the advertisement and only a reference is made to the entire class of products in its generic sense, and whether when an entire class of products is disparaged, can a market leader in the category of products or manufacturer thereof file a suit against such disparagement? Let's understand the factual matrix.
The plaintiff, Hindustan Unilever, is engaged in the business of manufacturing and selling fast-moving consumer goods, including frozen desserts and ice creams under the mark of Quality Walls. The products of Hindustan Unilever enjoy a very high reputation, and Quality Walls has been a well-known brand in India. The defendant number 1, the Gujarat Co-Operative Milk Marketing Federation Ltd, is a cooperative body of milk producers in Gujarat and is engaged in marketing of various dairy and dairy-based products, including ice creams, under the mark Amul, and has been a competitor of Hindustan Unilever. The defendant number 2, FCB Ulka Advertising Private Ltd, is an advertising agency. The suit was filed by Hindustan Unilever to restrain defendant numbers 1 and 2 from telecasting or broadcasting or otherwise howsoever communicating to the public or publishing television commercials disparaging or denigrating Hindustan Unilever's Quality Walls products. Hindustan Unilever alleged that the defendant number 1 in television commercials misleads the consumers of frozen desserts by stating that Amul ice cream contains pure milk, whereas frozen desserts contain vanaspati, and which admittedly was bad for health. The said television commercials sought to influence the customers to refrain from buying or consuming frozen desserts. The present suit is in the nature of an action for generic disparagement or slander of goods of the product category dairy-based desserts, referred to as frozen desserts. Hindustan Unilever further alleged that though in the impugned television commercials no reference or mention was made about its frozen dessert products, but the kind of comparison made in the television commercials was obviously and unmistakably directed to the Quality Walls products and directly affects its business.
The High Court gave an interesting decision in favor of Hindustan Unilever by holding that defendant number 1 was guilty of disparaging the entire category of frozen desserts, which include the products manufactured by Hindustan Unilever also. The court held that generic disparagement of a rival product without specifically identifying or pinpointing the rival product is equally objectionable. Let's understand why.
Even if there is no direct reference to the product of Hindustan Unilever and only a reference is made to the entire category of frozen desserts in its generic sense, even in those circumstances, disparagement is possible. Any campaign to educate the members of the public by placing before them the true and correct facts and ingredients used in a product should always be welcome. However, no manufacturer can place misleading information before the consumers qua the product of his rivals and thereby disparage or discredit such product, including influencing the customer to not buy the same. Content and storyline of the impugned television commercials, which, if seen as a whole, conveys a malicious and negative message that frozen desserts contain vanaspati, which is perceived as unhealthy and are inferior to ice creams, and are not meant to be given to children and should not be purchased.
In a nutshell, the High Court allowed the case of Hindustan Unilever Ltd and held that no manufacturer can place misleading information before the consumers qua the product of his rivals and thereby disparage such products in the garb of educating and or bringing in the correct facts before the members of the public, and when the entire class of products is disparaged, a market leader in the category of products can file a suit against such disparagement. Now let's move on to our second case, which pertains to Insolvency and Bankruptcy Code 2016 and Banking Regulation Act 1949. The key issue was whether, by the virtue of press release dated 13 June 2017, RBI has the power to issue directions to the banks to see that there is proper recovery of public money, and whether press release dated 13 June 2017 results into infringing any fundamental rights. Let's first understand the factual matrix.
In the present case, the petitioner is Essar Steel India Ltd. Essar Steel challenged the decision of the Reserve Bank of India directing banks to initiate proceedings against 12 companies, including Essar Steel, under the provisions of the Insolvency and Bankruptcy Code. As per press release dated 13th June 2017, intention which was disclosed by the RBI was clear that they will identify the accounts, will issue directions to the banks to file insolvency proceedings under the Bankruptcy Code, and such cases will be accorded priority by the National Company Law Tribunal. This means the NCLT had to give priority to cases filed by directives of RBI against the cases which were filed by other creditors or petitioners before it. Later, the RBI admitted that there was a mistake on its part. There was improper drafting, but not the intention to order NCLT to give priority to cases as per RBI directives, as was visualized from para 5 of the press release dated 13th of June 2017, and confirmed that the RBI would issue corrigendum to delete such line. In turn, the RBI issued the corrigendum on 8th of July 2017. The case of the Essar Steel was that when the restructuring proposal was made under active consideration by the banks under the mandatory circulars issued by the RBI, it could not have issued a directive to the banks to take action to approach the NCLT under the Insolvency and Bankruptcy Code 2016 for resolution of the debt. Essar Steel further submitted that in fact it had paid rupees 3,467 crores in the last 15 months to the banks and financial institutions. In these circumstances, there was a clear conflict between the existing circulars issued under Section 35AA of the Banking Regulation Act, which were binding on the banks and under which restructuring proposal was almost on the verge of being finalized, and the recent directive of the RBI issued on 13th of June 2017 directing the banks to take action of filing insolvency petitions. According to Essar Steel, the initiation of proceedings under the Bankruptcy Code by virtue of circular dated 13th of June 2017 issued by RBI results in coercive steps including mandatory suspension of the functioning of the Board of Directors and surrender of management to insolvency resolution professional. Such harsh consequences ought to be resorted to only when there was no other resolution or reconstruction of the company is not possible.
The RBI, based on the recommendations of the Internal Advisory Committee, issued directions to the banks to file for insolvency proceedings under the Insolvency and Bankruptcy Code in respect of identified accounts. The High Court dismissed the Essar Steel case against insolvency proceedings but draws Lakshman Rekha for RBI. The court indicated that the company could raise various issues before the National Company Law Tribunal, which will hear the bankruptcy case.
Mere filing of application would not amount to admitting or allowing the petition for insolvency without offering reasonable opportunity to the Essar Steel. Therefore, the NCLT would decide on its own, based upon the factual details, that whether the insolvency petition is required to be entertained as such or not. By virtue of press release dated 13th of June 2017, the RBI has powers to issue directions to bank and banking companies so as to see that there is proper recovery of public money. Therefore, the issuance of press release alone cannot be quashed and set aside. Section 35AA makes it clear that the RBI is authorized to issue directions to initiate insolvency resolution process in respect of a default. An explanation makes it clear that the default has the same meaning as assigned to it in clause 12 of section 3 of the Insolvency and Bankruptcy Code. Therefore, when Essar Steel did not pay its debt of more than rupees 32,000 crores at the end of 31st of March 2017, it is obvious that the RBI is authorized to direct any banking company to initiate insolvency resolution process. The court noted that insofar as Essar Steel's exercise of restructuring through joint lenders forum was concerned, it would be appropriate not to enter into any determination on such point, since that would be the subject matter before the NCLT, and therefore it was left open for determination in accordance with law.
The High Court held that RBI has to be careful while issuing press releases, and it must be in consonance with the constitutional mandates based upon sound principles of law. Banking company is entitled to initiate insolvency proceedings even without the directions of RBI under section 35AA of the Act. By virtue of press release dated 13 June 2017, RBI has the power to issue directions to the banks to see that there is proper recovery of public money, and press release dated 13 June 2017 does not result in infringing any fundamental right. With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for our upcoming videos. Please send in your suggestions at editor@tiol.in. Thank you for watching. Goodbye.